Lawyers were back in a D.C. court Thursday to discuss the conspiracy and obstruction case charging Donald Trump with interfering with the 2020 election. It was the first hearing since the Supreme Court ruled that the former president and all former and current presidents have immunity from criminal prosecution for official acts taken in office. Trump's lawyers are now pushing to have charges against him dismissed because of that ruling. CBS News campaign reporter and attorney Katrina Kaufman joins me now. Katrina, what was the purpose of this specific hearing?
Well, to begin with, it was meant to chart a path forward for this case, although it also became a brief arraignment for Donald Trump, who waived his right to appear. But because special counsel Jack Smith came out with a new superseding indictment, Trump also had to enter a new plea of not guilty through his attorney. But the bulk of today was really spent with Judge Chutkan coming together with the parties for the first time in over a year, John, and talking about their different views on how this case should proceed. The prosecution wanted to start with an opening brief about the issue of presidential immunity, whereas Trump's team laid out a plan that went into 2025 and started with their contention that special counsel Jack Smith is not even lawfully appointed or funded, which is how he just got his Florida case dismissed, although it's important to note that there is binding D.C. precedent on that issue.
So Judge Chutkan said that setting a trial date would be, quote, an exercise in futility. Why did she say that?
So both Judge Chutkan and the prosecution acknowledge that there will be at least one more interlocutory appeal in this case when it comes to the issue of immunity. Judge Chutkan will be applying the Supreme Court's immunity ruling for the first time to this superseding indictment, and she knows that Trump is going to appeal that back up to the Supreme Court once she makes determinations. Part of the issue here is that there are aspects of the immunity ruling that are vague. For one, you have to distinguish between what is an official act and what is a private act. There are arguments around that. And then there's also this issue of presumptive immunity for some official acts. For example, one thing that came up in court is Trump's team thinks that just because former Vice President Mike Pence was discussed in the superseding indictment and evidence about him was presented to the grand jury, that makes the superseding indictment invalid. They say that he is covered by the immunity ruling. And so that's just one example of issues that are going to come up as this case proceeds.
And finally, the judge did seem, though, even though she recognized the fact that this is going to bounce around for a while, she did seem inclined to allow the special prosecutor to lay out part of the case, which would then, I presume, contain possibly all kinds of new information that he's come up with in his investigation.
Exactly. And actually, within hours after the hearing, she has already put out her order, and she is going in line with what the prosecution asked for. They have a brief on presidential immunity due September 26th. And what's going to be interesting about that is they say it will contain both pled and unpled facts. That means new information about Donald Trump could come to light before the election, even though we're not going to have a trial yet. And this is something that his lawyer also took issue with today. He tried to push back, saying that he was worried about more information coming out at a sensitive time, alluding to the fact that we're bumping up on the election. Now, Judge Chutkan made it very clear in her courtroom today that the electoral calendar will not be a factor for her. She said she's not weighing the presidency, she's weighing a 4-count indictment, and that she is not going to plan her trial around the election or take it into account with her decision-making.